Good afternoon, everybody. Great to see such a nice turnout for our annual Supreme Court preview panel. And I'm Lee Lieberman-Otis. I'm the Senior Vice President of the Society and the Director of our Faculty Division, and we regularly co-sponsor this event with our colleagues in the practice groups. We're just delighted to have, for your listening pleasure and watching pleasure, a terrific panel. Without further ado, let me turn things over to our moderator, Adam Liptak, who will get us started.
Hello, welcome. I'm Adam Liptak. I cover the Supreme Court for the New York Times. I'm going to introduce our panelists very quickly. Additional information about them is available on the internet. Going from left to right, Roman Martinez is a partner at Latham and Watkins, a veteran of the SG's office, and recently the veteran of countless SCOTUS previews. I most recently saw him about an hour and a half ago at the Georgetown preview, summer of the weekend at the William & Mary preview. We'll be doing another one tomorrow. Roman, nice to see you again.
Good to see you, Adam.
Derek Muller is a law professor at the University of Iowa with many interests, but among them election law. Virginia Seitz is a partner at Sidley Austin and was formerly Assistant Attorney General of the Office of Legal Counsel in the Department of Justice in the Obama administration. Carrie Severino is President of Judicial Crisis Network. David Cole of the ACLU was meant to be with us today and was called away for a family emergency. And I'm delighted to say that Amanda Shanor will fill in for him. She's an assistant professor at the Wharton School of the University of Pennsylvania, and before that worked in the National Legal Department of the American Civil Liberties Union on Supreme Court litigation there, including the Masterpiece Cake Shop case. And finally, Devin Westhill is President and General Counsel of the Center for Equal Opportunity. So here's how we're going to do this. The format is a little different, and I think it should turn out to be quite lively. We're going to have one round of presentations on a bunch of the interesting cases in this big coming term. The panelists will spend maybe 5 minutes each on them. I may interject the occasional question, and then we'll have a round of responses to whatever the panelists want to address, and then we'll do it again, and then we'll have your questions, including from people online, so prepare yourselves. We're going to start with Roman, who's going to talk about a case to be argued almost as soon as the court returns to the bench in October, and it's a case he himself will argue one side of, Andy Warhol Foundation for the Visual Arts against Goldsmith. Tell us about your case, Roman.
Thanks, Adam, and thanks to all of you for coming and for the Federalist Society for having us. It's great to be with you all. So the Warhol versus Goldsmith case is a very significant or potentially significant copyright case that will likely provide the world with clarity, hopefully more clarity, about how the fair use defense to copyright infringement works, especially in the context of visual art or situations in which you have an original creative copyrighted work, the elements of which are then used by a different artist or creator in a follow-on work. As Adam said, I'm representing the Andy Warhol Foundation in this case. So, of course, I believe my side is correct. I'm going to try to keep it fair and balanced and just sort of present sort of both sides as fairly as I can here. So just the legal background very quickly. As most of you know, the Copyright Act protects original works of art, including visual art and photography. It gives creators exclusive rights to reproduce, distribute, and display their work. And also it gives copyright holders the exclusive right to prepare derivative works based on their work. In addition to these protections, though, for copyright holders, there's also a defense that people who otherwise would qualify as, infringing those copyrights can invoke. And the defense is the fair use defense. The The idea here is that there's sometimes where, as a matter of policy, we want to allow people to use and do all those things that you otherwise wouldn't be allowed to do with respect to someone else's copyrighted work. And the statute is not, it's got statutory language, it's not super specific or clear. There's sort of 4 factors that need to be weighed when considering whether a use of someone else's copyrighted work is fair use and thus exempt from copyright liability. The 2 that tend to be the ones that get the most attention are the first fair use factor, which looks at the purpose and character of the use, and then the 4th fair use factor, which looks at the extent to which the follow-on use will diminish the market for the value of the original work. The issue in the Warhol case is how to define and apply the first factor, the purpose and character factor, which the Supreme Court and the lower courts commonly refer to as sort of the transformative use factor. What's the test for transformative use? It's important to copyright law, but it's also important to remember that this is just one of the 4 factors that has to be balanced. In a case called Campbell involving, I'm sure everyone's favorite music group, Two Live Crew, about 30 years ago, the Supreme Court addressed this question of fair use and of the first fair use factor. Two Live Crew, which is sort of a rap group that somewhat known for its off-color, raunchy lyrics, they had borrowed significant quantities of the Roy Orbison song, Oh Pretty Woman, and had done what they described as a parody of that song that was a little bit more vulgar than Roy Orbison had in mind. And the court had to figure out whether that was, whether Two Live Crew's use of significant elements of the underlying Orbison work were fair use. And it announced a test, and essentially the test for the first factor turns on, it says that the follow-on work is transformative if it adds something new to the work with a further purpose or different character, altering the first with new expression, meaning, or message. So new expression, meaning, or message, we think is the test, and that's been that's sort of the standard formulation that's been used by the lower courts and occasionally by the Supreme Court since then. The facts of our case: Lynn Goldsmith is a photographer focusing mainly on sort of photographing rock musicians. She took some photographs of the singer Prince back in 1981. She wanted to show Prince in his sort of vulnerable, sort of very human state. So she brought him into the studio and took various photographs that she then would occasionally want to use for licensing purposes down the road. In 1984, Vanity Fair was doing an article on Prince, who at that point was emerging as a huge sort of up-and-coming celebrity. So they had an article called Purple Fame, and they wanted a picture to kind of go along with that article. So they licensed from Goldsmith the right to use her photograph as an artist reference for a work that Andy Warhol was going to do. So Andy Warhol did what all of you would recognize as a kind of characteristically Warhol-looking silkscreen work, where he took, he sort of cropped the photograph and then silkscreened it, changed the colors, did the psychedelic colors, flattened the image, and sort of created what might be thought of as sort of a classic Warhol-looking portrait, sort of like the ones of Marilyn Monroe that I'm sure everyone has seen. So Vanity Fair ran that work. Warhol also created 15 other works based on the photograph at the same time. Vanity Fair ran one of them in 1984, accompanying the article. Nothing happened for about 30 years, and then Prince passed away in 2016, at which point Condé Nast wanted to do a commemorative story on Prince, so they went to the Andy Warhol Foundation to try to use one of the 16 works and to kind of illustrate that commemorative edition to go on the cover. And they used a different one of Warhol's works and licensed that work from the Warhol Foundation. At that point, Goldsmith saw the Warhol work on the cover and said, hey, that sort of looks like my photograph. And so she engaged in discussions, and eventually everyone sued each other to figure out whether this was copyright infringement, whether it was fair use, both with respect to the particular work that was displayed on the Condé Nast piece in 2016, but also the creation of the works. The district court held that it was fair use, basically applying what we think is the correct approach under the Campbell meaning or message test. The Second Circuit reversed, and it seemed to sort of, in our view, narrow and in some ways really transform the transformative use test that the Supreme Court had announced. It focused a lot on the degree of visual similarity between the Goldsmith photo and the Warhol work instead of focusing on the meaning or message. We asked for certiorari, we got certiorari, and now we're in the Supreme Court. And the basic arguments there, we sort of cite Campbell, the meaning or message test. We emphasize that this test is intended to carry out the overarching purposes of copyright law, which is to promote creativity for the public good. We think that the legal test follows from Campbell. We think that making it harder for follow-on artists to borrow works in circumstances where they really are creating new art and adding meaning or message that's different from the original, we think that is extremely important to incentivize and protect artists who do that. It's not just Warhol, it's a whole, artists forever have been borrowing elements of each other's work, and especially certain artistic movements in the late 20th century, pop art. We also think that a ruling against us would disincentivize the creation of new follow-on works that borrow from original, thereby harming creative expression. It would also threaten the ability of museums and others to display works that are potentially not protected by copyright when they were created. For her part, Goldsmith argues that the right way to think about the test under the first factor is that a use should be considered transformative only when the follow-on work necessarily requires copying from the original and doesn't substitute for the original in the market. She says that our understanding of the Campbell test allows for too much copying, that this would disincentivize the creation of the original work. So that is sort of the fair and balanced summary. I'll just make one or two just very quick observations about the case. I think this is potentially a significant case for the whole kind of creative realm. Not just visual art, because obviously a lot of whether we're talking about artists or movies or all sorts of different areas in when you have sort of original works of creation that are copyrighted, and you have follow-on users who want to use and build on the creations of others. A lot of the analysis in those types of cases is going to turn on the four factors, and especially factor one. So it's potentially very significant. I think the court has a lot of high-profile, politically charged cases. I don't think this is a politically charged case. I think this is a tricky case. I don't see this case as having a political valence among the justices one way or the other. And I also think this is an especially interesting case, is my final point, because although the court in these statutory cases is often looking very closely at the text and the history of the particular statutes, this is a case where the text itself was sort of understood to carry with it a lot of sort of policy, a policy-based rationale, and they sort of wanted to codify what had been the common law approach. So I think a lot of the debate and discussion at oral argument is likely to turn on the policy implications of our rule, or our understanding of the rule, and the policy implications of Goldsmith's understanding of her rule. So I will stop there. Thank you, Adam.
Thank you. That was a very, very nice and truly balanced presentation. Let me ask you just one quick follow-on question. What I struggle with in this case is trying to figure out what transformation means. Is it merely building on the earlier work, or do you have to comment on the earlier work?
Right. So I think the Two Live Crew case, the Campbell case, was a little bit easier because they were both building on the earlier work and adding new meanings and messages to it, but it was a parody. And so part of the meaning and message that they were trying to communicate was sort of making fun of Orbison's work. And so Goldsmith says, well, in that case, there's more of a justification for copying, because in order to make fun of someone else's work through a parody, you need to kind of use some of their work. We think that the way that the court announced that test and the way that the court has thought about the meaning or message test in subsequent cases, it doesn't require commenting on the original work, but rather the purpose of copyright is to promote the creativity and innovation generally, and there's no good reason to just limit transformation only to circumstances in which you're commenting on the first work.
Great. Derek, tell us about the independent state legislature theory, doctrine, thing.
The thing. Yeah, I call it the legislature thereof clause of the Constitution, but that has not gained as much popular notoriety in the media. So this is Moore versus Harper coming out of North Carolina. So the Supreme Court a couple of years ago, also in a case out of North Carolina, said that partisan gerrymandering claims, that is, claims that excessively entrench one political party at the expense of another in legislative redistricting, were non-justiciable in the federal courts. And so there's been a lot of efforts to look for other places for addressing partisan gerrymandering, in the legislatures, by ballot initiative, whatever it might be. But another avenue has been by litigation in the state courts under the state constitution. And North Carolina had a case in the state courts where the state Supreme Court looked at its constitution, which for some time had not been perceived as having an anti-gerrymandering clause. And in fact, there's a previous precedent suggesting that it was non-justiciable in the state courts of North Carolina. But it looked at provisions of the state constitution, 4 different clauses: the free speech clause, the petitioning clause, the free and fair elections clause, the equal protection clause. And it created what one might say, a penumbra formed by emanations to conclude there was an anti-gerrymandering provision in the state constitution which prohibited the state legislature from drawing districts as it had done. So this is a state constitutional law case, and most of the time that would be the end of it. But the legislature appealed and said, well, wait a minute. We are supposed to be drawing these districts pursuant to a constitutional mandate. Article 1, Section 4 of the Constitution says that the state is supposed to prescribe the manner of holding elections, but it's done so by the legislature thereof in the state. And North Carolina's argument is, well, this isn't the legislature doing it. We drew the maps, and the state Supreme Court stepped in and told us under the state constitution we can't do that, and has effectively usurped our authority under the federal constitution granted to us to draw these maps. So there are a couple different ways to think about this case. One is there's some history, and it goes back 200 years, and it's very contested, and there's a lot of literature written about it. But the most recent sort of iteration has come up since 2000 in Bush versus Gore, where in a concurring opinion, Chief Justice Rehnquist, joined by Justices Scalia and Thomas, wrote under a parallel provision of the federal constitution, the Presidential Electors Clause, that this word legislature has to mean something. And what was actually happening in 2000 was the Florida Supreme Court showing up and reading a statute that the legislature wrote that said shall, and interpreting that to mean may, and construing a bunch of things inconsistent with what the legislature had wanted. So this has been floating around, especially for the last 20 or so years. Some justices have been writing separately in a series of emergency appeals before the Supreme Court as elections sort of draw close. But the question here, right, is there some outer bounds to what the legislature's authority is and what other institutions in the state can otherwise serve as checks or restraints on that authority? So on the one hand, the case is very limited. Right? It only applies to federal elections. It doesn't apply to state elections or local elections, because these are delegated functions here for federal elections under the Constitution. It doesn't allow them to ignore the United States Constitution, the Equal Protection Clause, the Due Process Clause. They still have to comply with federal law. Congress can always step in with the Voting Rights Act or with the Help America Vote Act or Motor Voter or whatever, and states have to comply with those rules. It does not allow states to ignore popular election results and appoint their own slate of presidential electors after an election. It's really sort of a discrete power that they have the power to set the time, place, and manner of rules for congressional elections. But potentially, depending on your view, and the amici are still sorting out what the view is, it could be very extensive. There are many provisions of state constitutions that purport to dictate certain rules about how elections are administered. And so on the one hand, you could say, well, state constitutions can never bind the legislature. The legislature is free to exercise this federal function, and it can't be checked by anyone else except Congress or the federal courts in the appropriate case. Other cases, they'll look at some precedents to say, well, we think there are these procedural checks on the legislature, the veto authority of the governor, or the ability of the people to act by referendum. Or a few years ago in Arizona, the people to act by ballot initiative to transfer legislative power into the hands of an independent redistricting commission. But those are sort of more specific grants of authority. And in this case, maybe, and Justice Alito wrote an opinion in one of the emergency appeals in this case, to say, well, there must be some limit to what the legislatures are what the state courts can do. And for the state courts to go fishing around a series of provisions of the state constitution to constrain the state legislature is inappropriate. So if the court chooses to sort of recognize that state legislatures have this authority to act independent of their state constitution or state legislatures, I think the real question in this case is going to be how far that authority extends. You can imagine them saying, no, the state courts are part of your legislative process, the state constitutions are part of the legislative process, we're not going to second guess that, we have no standards to evaluate what that looks like, all the way to the more extreme example of essentially the state constitutions and state courts can't act as independent checks, at least in federal elections. And if it wants to occupy some middle ground, which some of the amici have already suggested they should do, the question is, what are things that go too far? Some clear statement rule from the state constitution, for instance. That gets into a different kind of line drawing exercise to figure out whether or not the courts are going to be able to come up with something that's administrable rather than something that they're going to have to keep policing over the decades ahead to the extent that they determine there is this constraint on how state courts operate. So that's the heart of what's happening here in Moore versus Harper.
Thanks, Derek. Is there a version of this case where it goes off on a narrow ground saying whatever the answer to the larger questions that you've laid out here are, the North Carolina legislature itself has delegated some judicial reviews to the state Supreme Court?
Yeah, so that's a tricky one, and I've seen this argument being raised. That is, there's a provision of state law that authorizes the state court to review those maps in redistricting, right? So there's no sort of stripping of jurisdiction from the state courts. But that kind of only gets you halfway home, right? Because what the legislature might well say is, well, that allows you to patrol, for instance, specific provisions of our state constitution. We have a series of cases that say you can't split counties because we have a constitutional amendment that expressly prohibits you from splitting up counties. I think it's another question about whether or not the state Supreme Court acted appropriately in construing its own constitution, which is, again, what this sort of very delicate question is about federal courts stepping in and saying that state courts have gone too far. So the jurisdiction sort of argument gets you part of the way there, but then the question is that underlying substance of whether what the state Supreme Court did was appropriate.
So we ended the last term with a big EPA case on climate change, and we're starting the next term with another EPA case, Sacket. Would you tell us about that, Carrie?
Sure. So as Derek kind of alluded to just now, that one of the challenges the court often faces, if you don't come up with a good, clear administrable rule, you end up in this sort of Sisyphean situation where you're constantly going back and having to decide the same case over and over and over again. And there are several examples that come up this term. I think the Harvard and UNC case is kind of one of them. 303 Creative is another one. And Sacket is also one. Not only because this literal case has already been to the Supreme Court before. It's not deja vu if you're like, I feel like I saw this one before. It has already been up to the Supreme Court on the question of whether they could even bring the case and had standing to bring the case in the first place. But really what's going on in Sacket is the court trying to make sense of an incredibly split ruling from 2006 interpreting what the words waters of the United States mean. And in that case, you had a plurality that said one thing, and you had Justice Kennedy saying another, and you had some dissents and other concurrences saying other things, and it's been kind of a mess to try to figure out. The whole question in the first place it is already messy, because what's going on here is the Army Corps of Engineers and the EPA trying to give effect to the Clean Water Act, which prohibits discharge of any pollutant by any persons without a permit into navigable waters, and they define that later as waters of the United States. So what are these waters of the United States? Here's what they're purported to be in this case. The Sackets are a couple that in 2007 bought or had a 2/3 of an acre plot of land. They wanted to build a family home on near Priest Lake, Idaho, and they had to fill part of the land, to prepare it for the home building. That the EPA decided that they had needed a permit to do this because their property constituted waters of the United States, and they needed a permit for this. Here's how the logic went for that. Priest Lake, which is undeniably navigable waters, clearly waters of the United States, is connected to, I had to even write this down because there's no way a human being can remember it. There's a non-navigable creek. So now non-navigable connected to the navigable waterways. Connected to that, there's a non-navigable man-made ditch. Connected to that, There are, and this is like, they have to use a lot of terms like navigable in fact and navigable, because it's like terms of art, is an adjacent in fact, because adjacency is another term that gets kind of used in different ways by different people. Adjacent in fact wetlands that are next to the man-made ditch that's next to the non-navigable creek that's next to the lake. Then you have a 30-foot wide road. And then you have the Sackett's property. So they don't even have lakefront property, and they have to deal with all this, right? They're on the other side of the wrong side of the road. But there are portions of the property that are alleged to be wetlands. We're not even far enough to know that they're convicted of being wetlands, but they have been alleged to be wetlands, and they are deemed to be similarly situated to the wetlands on the other side of the 30-foot road, which then through a series of navigable and non-navigable, man-made and natural creeks and things do eventually connect to something. This is how far we have gotten with the interpretation of what is the waters of the United States. So it's not clear that it has to be water, and it's not clear whether it has to be adjacent to different things. Historically, what the history, we have the Supreme Court stepping in and saying, if it's adjacent wetlands to water, it counts as water. So even though it's kind of land, it's kind of water, if you have adjacency, we know it's water. If it's only a seasonal pond that's not adjacent to anything, we know that's not okay. But now we get this middle territory of what do you have when you have wetlands that, so they're not the water themselves, but they're not actually adjacent to navigable in fact waters, because obviously you can't navigate a wet land very well. So the challenge is, and the briefs really fall into the same camps as the various opinions in the Rapinos case. The question is, do you go with Justice Scalia's argument in there, which had a two-part test? He said you have to have, whatever it is, it has to first of all be actually waters of the United States on the one side of it. You can't start with something that's not even water. And it has to have for a wetland to get counted as water of the United States, there has to be some continuous surface connection. Because Justice Scalia argued, well, the only reason we're counting something that is land as water is the fact that the boundaries are actually very difficult to draw. If you've ever walked, to the edge of a pond and then kept walking and you're in the marshes and you're like, at what point? At some point you know you're dry, and at some point you know you're wet, and in the middle you're just sloppy. This case happens in the sloppy, and Justice Scalia said, well, if you can't really distinguish the edges, that's fine, we're gonna count that, but you have to have this adjacency. The other approach, which is Justice Kennedy's approach, said you just have to have a significant nexus, and this is a term that came from the second of those two previous cases that I talked about the detached pond that was a seasonal pond that wasn't attached to any other. They said there's not a significant nexus in that case, and so Justice Kennedy said, okay, significant nexus are the key words. And the challenge is, his opinion was, it's just very hard to exactly sort out what does that significant nexus mean. He said, for example, you need to do a case-by-case analysis, but then he also said maybe you do a case-by-case analysis of one wetland and then you can extrapolate that to other wetlands, so not really case-by-case. It can be very challenging if you're the landowner or if you're the Army Corps of Engineers to know how each case is going to go, and it's very hard to get a consistent ruling on that from various courts. So this case really presents an opportunity for the Supreme Court to go back and say, explain. I would think it would be more helpful to explain in a clearer way than this vague significant nexus test has, to clarify what is the waters of the United States going to entail. I think that will afford not only some closure to people like the Sackets, but there's a lot of land, agricultural land and just land, residential land like this, where it has huge implications for the kind of permitting and the extent to which a landowner has to jump through hoops to be able to use their own property. So that hopefully this is the last time you'll have to hear from the Sackets in the Supreme Court, but maybe I'm not completely holding my breath.
Thank you. At a lot of these previews, we haven't spent enough time on the business docket, and I'm happy to say this is a change, because Virginia will tell us about a couple of interesting cases on the business docket.
So, am I on? So I'm calling this hogs and trains, in a term that's got teed up affirmative action and election law and discrimination and religions. Why do you care about hogs and trains? But I promise that you do. In California Pork Producers versus Ross, the court will consider a California law that prohibits the imports of certain pork products if the breeding hogs are raised in what California defines as cruel conditions. California is a huge market for pork and pork products, so that has the effect of causing pork producers in other states to comply with California's requirements. And so then the question is whether California law's indirect control of the conditions of pigs in other states violates the Dormant Commerce Clause of the Constitution, which forbids states to regulate conduct in other states or to put an undue burden on interstate commerce. So California is using its market size and its muscle, not only with respect to pigs, it's also used this tool to try to force changes in fuel economy as well. And it's going to be interesting to see whether the court's willing to breathe new life or rigor into Pike versus Bruce Church. That case asks whether burdens on commerce are excessive in relation to what counts as a local benefit. California's opponents say California has no interest in how pigs are raised in other states, but California says it's entitled to take into account its citizens' moral views about animal welfare as it relates to their own food consumption. So I do think this case will shed significant light on why states face constitutional restrictions on making laws that apply on their face only in the state. After all, this law simply limits imports of certain kinds of pork products. It doesn't directly regulate pork production elsewhere. So does our federalism let California control imports into the state in this way? Or does our federalism require California to allow other states to produce pork as they would choose to do so without the undue burden of being banned from California's markets? It's also interesting to think about whether the issue is different in states with smaller markets for pork. Do such states have more ability to control their imports because they have so much less leverage to change the behavior of producers in other states? And what local interests, what kinds of local interests are sufficient to overcome the burden that California's law places on commerce? So now let's move to trains. Pennsylvania has enacted a law that says if a company registers to do business in Pennsylvania, it's consenting to be sued in Pennsylvania courts for its actions anywhere in the country. Norfolk Southern, whose trains run through Pennsylvania, objects to being sued there for an accident that occurred in another state and injured a person who has no connection to Pennsylvania. In Mallory versus Norfolk Southern, the railroad contends the Constitution's Due Process Clause bars states from requiring corporations to consent to personal jurisdiction as a condition of doing business in the state. If Pennsylvania can do so, the railroad says, it can extend its view of the law, here tort law, to events and residents in other states wholly unconnected to Pennsylvania. And of course, if a state can force companies into their courts for conduct unrelated to Pennsylvania, then Pennsylvania judges and juries will decide whether a defendant has violated the law and what the punishment is, even for conduct in and residents of other states. So does our federalism allow Pennsylvania to control who can do business within its borders in this way? Or does it require Pennsylvania to allow companies to do business there without subjecting themselves to Pennsylvania law for actions that have no connection to the state? Should Pennsylvania really be able to prevent other states from deciding the law that applies to persons and events more closely connected to them? And of course, these federalism questions are fraught today because states have such different views on numerous political and policy issues and are increasingly seeking to use state law to further those political and policy positions, often in ways that assert control over people and events outside their borders. So one example is that states are particularly interested in the post-Dobbs world of attempting to enact laws that would limit or protect abortion or aid to abortion outside their borders. For example, Texas and Missouri have considered laws imposing liability on those who travel out of state to obtain abortions or assist others to do so. Others have proposed laws to prevent companies who register to do business in a state from providing abortion benefits to employees. On the other side, abortion-supportive states will seek to expand abortion access and have passed laws that protect providers from legal sanctions for helping out-of-state residents obtain abortions. The Supreme Court will understand that its interpretation of the Dormant Commerce Clause in Ross or the extent of a state's ability to impose conditions on companies that seek to do business within its borders, may well determine whether and what extent states can pass laws with significant effects on persons and conduct in other states. Each side in this debate has a very different vision of our federal system.
Do these two cases, Virginia, the trains and the hogs cases, are they likely to sort themselves out along the usual ideological lines, or are there some scrambled commitments here?
I think there are scrambled commitments here, and in particular, Justice Thomas has a long and very interesting view about the Dormant Commerce Clause that may have a significant effect on how he sees Ross, I think. So I think there is some lack of predictability here for these lineups.
All right, Devin, probably the biggest cases of the term, the Harvard and UNC cases. Tell us about them.
Thank you very much, Adam. And notwithstanding what Adam just said, I think we all can agree this is the least controversial of the cases this term I've been asked to talk about. First of all, I want to thank the Federalist Society for inviting me. I've been a friend of the Federalist Society for a lot of years, and it's really truly an honor to be able to speak on this panel with all of these experts, because I'm just a simple country lawyer, as many of you know. So all I can really talk about is, are these cases. I have some thoughts on them. So the cases I've been asked to talk about are the two cases, Students for Fair Admissions versus Harvard and SFFA versus University of North Carolina at Chapel Hill. In these cases, SFFA petitioners are challenging race preferential treatment in college admissions, commonly referred to as affirmative action. Specifically, that Black, Hispanic, and other minority applicants are given preferences over and at the expense of white and especially Asian American applicants. And before I get too much further, I just want to say that I'm personally very interested in these cases, in addition to my professional interest. I am a biracial Black man from the South, almost certainly the descendant of West African American slaves. My wife is the daughter of a Vietnamese refugee to the United States, and our two children are a combination of those races and ethnicities, and many other things are much more important than that combination. And to make things worse, or better, as the case may be, my undergraduate degree is at the University of North Carolina at Chapel Hill. So way back in the before times, before COVID, in the year of our Lord, 2014, Students for Fair Admissions, which is a combination of about 20,000 students and parents, filed suit in federal district court against Harvard and at the same time against the University of North Carolina, alleging that the race-conscious regimes at these schools were illegal pursuant to Title VI, which prohibits, among other things, racial discrimination by schools who receive federal funding, which both Harvard and UNC do very gleefully. UNC is also being challenged under the Equal Protection Clause of the 14th Amendment since it's a public school. The school's response to the suit was, yeah, so what? It's legal what we're doing. The decisions, they say, for admission are based on a holistic admissions criteria where race is a mere factor among many others in the pursuit of benefits that flow from campus racial diversity, which the Supreme Court says is compelling. And you know what? They're right. The Supreme Court, since the late 70s, over 40 years, I mean, that predates the Federalist Society, can you believe that? Older than me, has permitted the use of race so long as quotas are not established, nor are schools racially balancing their incoming classes. Both of those sorts of activities would be illegal. Through a string of cases since 1978, Bakke case, which began to allow this officially out of California, Gratz and Grutter, Michigan cases in the early 2000s, and the Fisher cases out of Texas in the 2010s. There's longstanding precedent for what the schools purport to be doing. One additional thing is that to survive, these regimes have to be their use of race has to be narrowly tailored, right? It has to be the least restrictive means for which they can advance this compelling interest of using race, and that there's no viable race-neutral alternative that they can turn to. And one important thing is that it has to be limited in time. They can't just in perpetuity be using race in their admissions criteria. So at the district court, Harvard won. At the district court, UNC won. The First Circuit agreed with the district court, and the Fourth Circuit, when the UNC case was appealed to the Fourth Circuit, actually never rendered a decision on the district court's decision. The UNC case went directly to the Supreme Court. An interesting thing here at the cert stage, I will say that the organization that I'm affiliated with, the Center for Equal Opportunity, has weighed in no less than 5 times in these cases, 2 amicus briefs at the cert stage and 3 at the merits stage. But at the cert stage, the court asked the Solicitor General, the Biden Solicitor General's office, to weigh in on how they felt about these cases and whether or not it should take these cases up. The Solicitor General essentially said, no, you shouldn't. The law is settled here. The court said, okay, hard pass, and granted cert. The court then consolidated these 2 cases, and then, I mention this just because it's just sort of interesting, then unconsolidated them when Judge Ketanji Brown Jackson was elevated to the Supreme Court. I find this actually a really interesting thing to have happened. The idea is that I think Justice Jackson can now weigh in on this matter in the UNC case, whereas she's not going to in the Harvard case because she's recused herself. She was a part of the Harvard Board of Overseers for a period of time and thinks that she should be recused from those cases. But she can weigh in on the UNC case. I think this is actually a good thing. I think it's important to hear from the first black female justice on the Supreme Court of the United States how she feels about race consciousness in American life. We don't have a good record of what her thoughts are on that. And I do think as we continue to, think about concerns about the legitimacy of the court, that it would be really a black mark on the court if the first black female justice didn't have an opportunity to weigh in on a major race issue like affirmative action. So I think that's a good thing. And oral argument is going to be, in both of these cases, an hour each on Halloween this year, so it'll be hopefully not scary. So I have a few other things I'd like to talk about. I think we might take it up in some of in the second round and in some of the Q&A, particularly curious things like what do we make of Justice O'Connor's prediction in Grutter that race-conscious admissions is not going to be necessary in 25 years? Questions about whether or not affirmative action is necessary for military readiness and national defense, and also just some practical implications, which I find probably much more interesting, and probably much more interesting to the vast majority of the country. What does this actually mean for minorities? What does it mean for the Asian American applicants in this country? What it means for the country going forward, and perhaps other race-conscious regimes in contracting and employment, et cetera.
Thank you. Amanda, tell us about what most people think of as a sequel to the Masterpiece Cake Shop case.
So, well, I'll say I'm really interested to hear what you're going to say on all those things. So,
good.
Yeah. Okay. Hi. Thanks so much for having me. It's really a pleasure to be here with you all and this illustrious panel. I have the pleasure today of talking about the Masterpiece Cake Shop secondary case, 303 Creative LLC v. Alanis, which involves a free speech challenge to the application of a public accommodations law, which is a type of civil rights law, to a wedding website company in Colorado. 303 Creative is one of the blockbusters this term, I think, in part because it bears both on the scope of speech protections in economic life, particularly for business owners, but also the degree to which businesses can refuse to serve customers. 303 Creative involves Colorado's public accommodations law, CADA, which was also at stake in Masterpiece Cake Shop. CADA prohibits businesses from, that hold themselves out as open to the public at large from refusing to serve goods or services or provide services based on a range of characteristics of customers, including sexual orientation. So that case, Masterpiece Cake Shop, is an important prequel to 303 Creative. So I'm going to say a couple things about it. Masterpiece, as you probably know, involved a baker who refused on religious grounds to bake a cake to celebrate a same-sex couple's wedding. Commentators in Masterpiece, I'll say like 303 Creative, were sure that the bakery was going to win. So like all of these panels, right, that's like what I would have said at that time. But what happened was, I think, surprising to a lot of people. In the case, the assumption was that the court took cert in Masterpiece to carve out a First Amendment sort of like exception to public accommodations laws, but the court ended up not doing that. And part of what's interesting is I say carve out and change the law because the court has actually, over a series of decades, heard many different constitutional challenges to commercial entities who wanted constitutional exemptions from having to provide goods or services to various sorts of folks in violation of public accommodations or anti-discrimination laws. And at each and every time, including Masterpiece Cake Shop, the court has rejected those, okay? So, but what's happening now with 303 Creative is that we have a new court. So in Masterpiece Cake Shop, the court didn't actually address the big free speech issues that were at play and instead took a narrow off-ramp, held very narrowly in favor of the baker, but on very established religion law grounds. And so those big First Amendment questions are now back up before the court, but before a new court. We have the expectation here, too, that probably the website owner will win. But let me tell you a little bit about what the key arguments are in the case. Rather than a baker, 303 Creative involves a business owner, Lori Smith, who would like to design websites for straight weddings, but for religious reasons, not same-sex ones. She filed a pre-enforcement challenge, meaning unlike in Masterpiece, there's not an actual couple here. Right? She wants a decision saying that she doesn't have to provide websites for gay couples. And very importantly, unlike Masterpiece, there's no religion claim at stake. This is only a free speech claim, which is important for a number of reasons. There's not an off-ramp for the court, right? I guess they could GVR, but I don't think they're going to do that. But it also means that the decision will not just be about people who oppose civil rights laws on religious grounds, but more generally, and that means it has potentially far broader implications for civil rights laws and other types of laws, as we'll talk about. 303 Creative's argument, well, I'll say one thing. Both of the arguments on both sides, I think the court is going to have problems with and be skeptical of and have concerns about the implications, okay, on both sides. 303 Creative's argument principally relies on a case called Hurley, which involved the application of a Massachusetts public accommodations law to a parade, and the court said that violated the First Amendment. Petitioners in 303 Creative take Hurley for the principle that public accommodations laws cannot constitutionally require someone to express a message that they don't wish to convey. Okay. The state's argument, by contrast, is that there's really not a First Amendment issue here because the law is only targeting commercial conduct, not message. So under the state's view, CADA lets businesses say whatever they want to say, make whatever messages they want to make. They just have to sell those messages equally in a non-discriminatory way. Okay, so there's super interesting and very hard questions at stake in this case. One of them is, who's an artist? The petitioners say that their exemption is only going to reach artists, and they concede that that it's not constitutional they don't have a constitutional right not to serve folks. Okay, Kristen Wagner, who maybe you all know from ADF, she got, I think, some really hard questions in Masterpiece about what's an artist, right? And part of the question is, if the court is going to go in favor of the website owner, what are the limits going to be? If a website design company is an artist, what about, the cake guy in Masterpiece, or a florist, or a chef, or a tailor, or a hair designer, or, an architect? I think as that becomes a little bit more amorphous, it may raise more concern on the court. There's also really interesting and important questions about the relationship between identity and message. So both petitioners in the state draw a distinction between refusals based on the identity of the consumer and the message conveyed by the product. But that line isn't always clear, right? Or at least it raises really tough questions. So what about when a photographer refuses to photograph a female CEO because he believes that a woman's place is in the home? Is that message or is that identity? What about if a florist refuses to provide a floral arrangement for a gay man's funeral because he doesn't want to memorialize that lifestyle? Or a baker that refuses to bake a birthday cake for a black child because he doesn't want to celebrate black lives? I think what's really hard here is that while 303 Creative concedes that businesses don't have a constitutional right to refuse to serve people based upon their identities, it's very hard to see how their argument that public accommodations can't be compelled to convey any message, how that it doesn't include that very idea. So let me say, for example, it's hard to see, for example, how refusing to provide sandwiches to black people in the 40s, I'm from Atlanta, doesn't send a message that somebody might say that they didn't want to convey. Or let's say, I don't think that immigrants should be in our country, and so I want to refuse to serve them in my shop, right? And so ultimately, this case is about whether or not this type of thing is something that the Constitution protects. Okay, on the other side of the ledger, we have really important questions about the scope of free speech in commercial life and of businesses. I think the state's argument is definitely going to trouble the court. For example, if a website designer is willing to design a website that says, Jesus blesses your wedding for a straight couple, does that mean that the law compel them to say the same thing for a gay one? And there's a host of other types of examples that you could raise like that I think are very troubling and are likely to be troubling for the court. Okay, so like in Masterpiece, I think there's good money on the website winning this case, but how it does so, or if it does so, may have enormous implications for expressive and associational rights in other economic settings and for anti-discrimination laws more broadly. And part of the question is how on earth are you going to cabin such an exception? So, if petitioners win this case, would another company have a right to decline to serve interracial or interfaith couples? I would assume so. Formerly divorced peoples, immigrants, unpopular religious or racial groups. Could a business run by a person of faith refuse to hire a woman, again based on religious or non-religious grounds? I think that this case tees up a bunch of very tough questions. And I think those implications, too, are likely to trouble some people on the court. So that's my summary of the Masterpiece follow-on. I'm really delighted to be here.
Thank you. So you say, and you're quite correct, Amanda, that this is not a religion case by its terms. It's a free expression case. Do they take the case without the religious background?
No, I don't think they do. I don't think they do. And I think that that's one of the things that's hard about this case, because it's going to be decided on really good, really bad, I don't know how you describe it, really specific facts that I think are likely to tee up certain types of feelings. And part of what I have tried to do, or think about it, and that I would encourage you to do, is think about it in a totally different context with the same rules. If we're going to be analytically sound, we say this is one First Amendment, it's for everybody. It's not just in this particular religious context where a lot of people are likely to agree. It may strike you differently.
All right. The next phase of this enterprise is we're going to go around the horn, and everyone can talk about and react to anything they've heard among all these many cases. Ramon, I know you need to leave in just a couple minutes, so I'm going to start with you.
Yeah, thanks, Adam. And I apologize. I need to leave to go to an argument that was scheduled after this panel, so I apologize for that. I guess I'll just pick up on Amanda's general comment about 303 Creative, because I do think that's sort of where the action is in the court in a lot of these types of cases. Amanda sort of said, look, it seems like probably the website's going to win, but there's just a real question about how they win. And I think that's probably true in the affirmative action case. We've seen that dynamic in other cases where you can kind of look at this court, it's a 6-3 court, you sort of know where they're coming at issues jurisprudentially. It might not be hard to predict the bottom line result, who wins, who loses, but a lot of the devil is going to be in working out the details, the scope of the rule. And I think in the affirmative action cases, this is really important. I think there's a very narrow way in which the challengers can win. They can win under the existing doctrine. The court can say, we don't need to overturn Grutter, or we don't need to resolve that because under the existing doctrine, the schools lose. And that would sort of kick the can down the road. Even if they overturn Grutter, though, the justices, I think, can frame the discussion in a way that's very broad or very narrow. And so I think one of the things that is going to be especially interesting to come out of that case is, for example, if Grutter is overturned, what will legislatures or what will schools be able to do if they do want to sort of promote diversity in the educational setting? Will they be able to use sort of approaches that do not explicitly take race into account, but are sort of adopted in part out of a desire to promote diversity? For example, could a school say, okay, we're not going to treat individual candidates differently on the basis of their race, but we're going to have a policy where we're going to allow the top 10% of any high school to get automatic admission to an in-state school. And that policy wouldn't treat people differently on the basis of race, but it might be adopted with knowledge that that a 10% policy like that would increase diversity. And so I think there's a lot of play in the joints, and I think what that sort of suggests to me is that with this court in particular, it's not just who wins or who loses, right versus left, but some of the nuances and the distinctions between different judges among the six on the conservative side, it can really drive a lot of the outcomes that's going to come out of these cases more generally. And with that, I will leave. And I'm so sorry to do this to you, but thank you all for having me. And sorry I have to leave early.
Derek, your reactions to what you've heard so far.
Sure. Well, first, coming from America's largest pork-producing state, I really hope California loses. But really, I want to focus on actually pick up on a different case that's going to be argued in the first week of the term. It's just to very briefly mention another election law case, which is Merrill versus Milligan, Section 2 redistricting case out of Alabama, which also has potential implications in Louisiana, at least in the immediate future. And just speaking very briefly, like there are a couple different ways the court can go with this case. And again, it's a challenge to Alabama's congressional redistricting map. It has long had a map with one majority black population district, one majority minority district to comply with Section 2 of the Voting Rights Act. There's a question about whether or not there needs to be a second majority minority district in the state of Alabama. On the one hand, it might be, and this is the argument that Alabama has, is look, this map, the only possible way you can get to this map is if you, to draw a second majority minority district, is to sort of look at race first and put all other sort of redistricting factors subservient to that. And they have testimony from the experts who came in the case saying, well, this is a non-negotiable principle to make sure that we are drawing a second majority black district. And the state of Alabama is saying, you sort of sacrificed some of our other communities of interest and other sorts of decisions that this three-judge panel did in drawing this map to sort of push this sort of racial preference here. And again, this is an interesting term and an interesting October to think about race under the Constitution and under federal statute. So that's Alabama's argument. And then, so this could go in a couple of different directions, I think. One is a narrow one saying, you're right, on this record, based upon the language we've used in other cases, the experts here really kind of overplayed their hand. The lower court kind of overplayed the evidence. This really should be something where you look at traditional redistricting criteria first, try to make it as compact as possible, adhere to the state's preferences, and race is something we consider later only as necessary to comply with Section 2 of the Voting Rights Act. And we're unable to do so without sort of just focusing exclusively on race. The broader one, I think this is the question. I don't think the court will go here, but it's the one that's been briefed, and it's one the court might choose, is to say something along the lines of Section 2 of the Voting Rights Act, which has long been used for redistricting and long applied in many legislative districts, is unconstitutional, or at least doesn't apply to redistricting. That's sort of, again, this sort of notion of how we think about Congress enacting statutes pertaining to race sort of exceeds congressional authority and is no longer something that we can say is permissible. So that's, again, a potential, I think, less likely outcome, but certainly something to watch as the court hears oral argument on this in the near future.
Thanks. Virginia?
So I just want to comment on more, because it seemed to me during 2020 that the court was not that excited about deciding or being perceived to have decided a presidential election, and it indicated this over and over again. But I think there's every reason to believe that litigation over the 2024 election will repeat the pattern after 2020. Many key states going into 2024 are internally divided with different parts of government controlled by different parties. So in swing states like Michigan, Pennsylvania, North Carolina, Wisconsin, you see Republicans in control of the state legislature and the governor a Democrat. And I think state legislatures in some states have been the locus of some of the more controversial post-election related activities, such as the post-election audits in Arizona, for example. So it's my sense that in any case that might affect the allocation of power, the court is going to have an instinct that it could get drawn into these problems in 2024 on a regular basis, and that it's going to be looking for a way to decide more to limit the amount of litigation post-election in 2024. And I just wonder, Derek, if you share the view that they're going to be looking for a clean or clear rule, or whether that's not going to be on their mind.
I think it's definitely on their mind. I think it's the amicus briefs, again, go in many different directions, I think, suggesting what those lines could be. But I think it's at the forefront of their mind to say these issues came up a lot in 2020. I think there's some unique reasons why they came up in 2020 because of COVID and some late-breaking changes that happened by the executive or by courts that were not sort of pre-authorized by the legislature. But I think they are concerned about the unintended consequences of a decision.
Yeah, I feel like it's any port in a storm these days, and so we're going to be seeing a lot of that absent a clear statement from the court.
Carrie?
Yeah, I guess I would just say that this theme of trying to have a consistent rule and the unintended consequences kind of goes through a lot of these cases, for the independent state legislature, to the 303 creative, of we are kind of trying to work on a project of how do we have a real rule of law governing here. So making sure that there are laws that you can live by, whether it's your side or the other side as the petitioner or the respondent. It could be, this time it's the North Carolina legislature is GOP controlled and the court is Democrat nominees, but it could flip. And similarly, you could, especially in a world where there's a lot of cancel culturing, and sometimes on both sides, it can. These are issues that are they're gonna come back, and can we have how do we organize our system so we can have a robust respect for the other person's conscience while still being able to function together. So I think those are going to be some of the big questions. I'm not sure that drawing some of the lines will be as actually, in terms of identity versus message, is going to be as hard in practice. I think some of the examples that you give are sure theoretical examples, but what we see in real life happening is much easier to draw those lines. So I think the court might be able to find a way to draw that in a clear way. I also, though, hope that, like in the election law cases, that whatever they come up with, it is a much clearer rule than they've come up with in previous terms, because I think we all are served well by having a clear system. I think one of the risks of having unclear rules is that it allows you to just insert your own political leaning or whichever way you want something to go into it. I think that's a little bit what's happening in some of the college admissions stuff. Well, if you have a very vague standard, it's hard to tell, is someone really making this decision based on race, or is it based on other factors? So I think we benefit from having clearer rules in all those cases, because then it doesn't allow the decision makers to simply hide behind a host of balancing tests and varying things that they're working with to do something to really, at the end of the day, just come to the result that they feel like is politically or personally is the right result. I think the rules work in the favor of clearer rules work in favor of having a rule of law equal standard applied across the board.
Amanda?
Me? Okay, great. So I'm really interested to hear what Devin's going to say, but I'm going to say about his cases a couple things. First, I was going to say what Roman says, which is the way that the decision is written in the affirmative action cases can have a huge effect, specifically if they decide to say that an interest in diversity is not a proper interest in this context. If they did that, it would mean that these type of race-neutral but diversity-oriented plans would probably go by the wayside, and that would be a much broader ruling than some of the other possibilities. I also think that his cases, the affirmative action cases, raise two other big issues for me. One is about history and tradition, right? Like the last term, the whole thing was about history and tradition. And I think there are really important questions about the history of the 13th, the Reconstruction Amendments, okay? And if you're a serious originalist, if you, like a lot of that history, I don't know, Randy Barnett has an article with Evan Bernick that y'all should look at, but about how that time period included a lot of things that were affirmative action on the basis of race. Like, what is 40 acres and a mule? What is 40 acres and a mule? Now, you could say, like I often say, like, okay, well, I'm not an originalist. But I think in this court, that should be an important question. Okay, I also think if we get a broad ruling, like colorblind ruling, and really double down on that idea in the affirmative action cases, I think that Title VII, so employment discrimination, is going to be the next thing to face significant constitutional challenge, in part because it requires employers to think about race in deciding how they're going to mitigate potential inequalities. And I think that there are also other types of laws that, I don't know, y'all may really like, that also may face these sorts of challenges, and that's what I expect we'll see relatively shortly.
Yeah, interesting. I guess I don't disagree with anything that you just said, honestly. I mean, the 14th Amendment issue, we have to understand the historical context within which sort of the 14th Amendment came about. And, immediately after the Civil War, there was a major concern in the country about what we do with slaves, and how we're going to make them full citizens and so forth. That's a long time ago. But one of the important things here in these cases is, in both the Harvard case and the UNC case, there's a Title VI claim, and I think this can be dispensed with the Title VI claim. And I think it's undeniable that when Title VI was passed, that it was clear that there was not going to be any exception for this sort of practice, whether it's diversity or whatever else, in the use of race. So it can be dispensed with that way. I wish Roman was staying a little bit longer because while I agree with a lot of what he said, I really don't see how it counts to failure here for the petitioners in these cases, particularly in Harvard. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. That's Chief Justice Roberts. Every time government makes race relevant to the distribution of benefits or burdens, it demeans us all. That's Justice Thomas, quintessential. Affirmative action is, quote unquote, systemic racial discrimination. That's Justice Alito and Fisher dissent. That's the three that we expect. I do think also, and I was reading recently, that Justice Barrett has voted with Justice Alito like 90% of the time in the last term, and on all major cases that we would consider major cases. The question is whether or not the Chief Justice, right, who has said, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, is whether or not he wants to be sort of the institutional man that he is and make sure that the court isn't, creating these major wild swings on really difficult issues at the court. They did that last term in Dobbs. I suspect that being the case, and he voted to overturn a row in that case. I suspect they will have the backbone to say what the law is, that there is an unequivocal ban on race and admissions, overturn Grutter, and they'll do it without as much concern as in the abortion case. The question is whether or not I'm right about that, and whether Chief Justice will peel off someone like Justice Kavanaugh to vote with him in some more narrow way, indicating that perhaps what the schools are doing is perfectly fine based on precedent, and quite frankly, we need sort of a major reason to overturn statutory precedent because Congress could have spoken on this and they haven't spoken on what we've done in this respect. I think that's just more unlikely. I'll stop there. Again, I'd like to talk about other things as well, and maybe we'll get to that in Q&A.
Thanks. So the original idea here was that we'd have a whole nother go-round around the horn and a bunch of presentations, but a lot of the panelists have gotten ahead of themselves and have talked about their topics already. The only thing I have in my notes is that Carrie has some additional thoughts on 303. I'm not going to stop anyone else from making another initial presentation, But that's the only thing I know.
I think I got my thoughts out already.
Your thoughts
so,
are out
yeah.
already.
Amanda did a
Anyone,
great job of
we're going to
summarizing
turn to
it, so,
questions in a
yeah.
second unless someone has other thoughts. All right. I welcome questions from people attending remotely. And we have microphones up, so anyone who has a question for the panel, please take your spots.
Hi. Thank you very much. I appreciate your presentations. I'm Randy May from the Free State Foundation. A couple days ago, the Fifth Circuit, as many of you probably know, suggested that the Texas law that prevents discriminatory treatment by the social media companies in their moderation practices was constitutional. It rejected a First Amendment challenge. A lot of people think that will go to the Supreme Court. I recognize you weren't talking about that case, and perhaps this may not be this next term, but it might be. If you have any thoughts, predictions about which way the Supreme Court will go if the Texas law or the Florida law, where the 11th Circuit went the other way, what the court is likely to do, I would be really interested in your predictions.
I'd welcome Amanda's thoughts, who's a real expert in these matters.
Yeah, so this is something I think a lot about. Really great question. So I don't think it'll come this term. I think it'll come next term, but it's definitely coming. There's a range of different state laws regulating social media companies in various ways. My speculation, and I guess I should say the larger question is, how are these cases that essentially tee up the property rights of somebody like Facebook, okay, and their ability to regulate what is really, they're at least going to argue, is their private space, right? And how they can curate it and what they can say and who they can invite. Again, there's a weird synergy actually between 303 Creative and these Facebook cases, right? Like it's about the right to exclude and kind of like a certain idea of property and also these free speech principles, okay? And then another kind of wing of the GOP interest in terms of asserting an understanding of viewpoint neutrality on and sort of like an idea that conservatives are being squashed out of the major social media companies. I suspect this court will go with property, okay? I think that that's doctrinally probably the right thing to do, at least in this particular moment, but the broader questions about how to negotiate these sort of like the viewpoint issues, which are again very similar to the questions in like 303 Creative, and essentially the property rights is a really is a fraught one that's going to be in front of the court, not just in this case, but in a bunch of others in the terms to come.
And I think Section 230 will end up playing a significant role in perhaps the way the court decides. Thanks very much. I appreciate it.
Thank you, sir.
Michael Rossman, Center for Individual Rights. I have like the panel to follow up on the stare decisis argument that Devin just mentioned right at the end of the presentations. So arguably in the affirmative action cases, the stare decisis argument is quite strong because it is a statute, and not only can Congress change it, but states already have changed it. Grutter and Fisher don't really apply in California or Washington or Michigan or Oklahoma. So it would seem that there's ways for the public to change the rule if they want to, and I was curious to see what the panel thought about how that might affect the outcome there. And second, if they don't overrule Fisher, whether the panel thinks, because there were trials in both of those cases, whether the court will be constrained by the findings of fact in those two cases.
I think I've given my thoughts on how the court can dispense with the argument of the 14th Amendment historical claim that it's not actually a complete bar on race-conscious, laws and policies, and that Title VI is easily dispensed with. That's not a, it's not a hard and fast rule that there has to be some super big, amazing reason why stare decisis must fall, or not be that persuasive in overturning some statutory decision. And I don't think that we have a composition on the court right now led by Justice Thomas who are going to be as persuaded by this norm as maybe earlier iterations of the court were. That's basically what I would say.
I think if there's ever a case that had a really strong argument for not following stare decisis with respect to its Grutter, which is almost expired under its own terms. So even if you leave it in place, we've got it till what, 2028? I mean, so if anytime you have a case that has implicitly admitted that it's not a real constitutional or like a really solid holding, but that it's one that we're just going to let sit until it's been, long enough to have figured your other things out, I think that the court isn't going to feel like it's bound by this last 3 years or whatever it needs to wait for the thing to expire.
I'll just add, I appreciate you saying that, Carrie. I'll just add that it's highly unlikely, as I suggested, that they're going to see another case like this within that quote-unquote expiration period either that Justice O'Connor laid out in Grutter, which is 25 years. Maybe won't need race preferences in this manner. Right? These cases, the Harvard and the UNC cases, have been wending their way through the courts for 8 years. They're not going to see another one within that 25-year period.
Yeah. Can I just say, I'm going to draw back to the originalism point, which is, okay, whatever about Grutter, right? The real important point is the 14th Amendment. Yeah. What was that context? And maybe that means O'Connor's wrong, right, in terms of what the meaning of the 14th Amendment is. If it really is grounded in the history and tradition of it, was something that was about anti-subordination as opposed to a notion of colorblindness, which is more modern, and maybe we think it's the constitutional right thing to do. But if we're thinking in terms of originalism or even these questions of stare decisis with regard to Grutter, I think that's a question that actually has to be faced if we're going to have a court that really thinks about rule of law for everyone as opposed to raising some of the legitimacy issues, of course, with the changed court that sort of haunt our panel.
That said, if they decide the Equal Protection Clause does require colorblindness, then Title VI has a problem.
Title VI goes down, Title VII goes
right.
up.
No, exactly. But unless you interpret them as colorblind, in which case they're great, but it's going to have an impact anyway.
And the whole concept of what is the compelling interest here that has to be completely rethought.
Yes. Trey Mayfield, Juris Day. This is actually a factual question for Devin. How did or do Harvard and UNC treat international students, Swedes versus Nigerians versus Chinese, in their diversity matrix?
That's interesting. I appreciate the question. Actually, I'm not sure. Based on what discovery discovery that's come out in these cases reveals, is they're just, as far as I'm aware, just lumped all together. Swedes or other European immigrants are lumped together, as far as I'm aware, as white applicants. Nigerian immigrants and multi-generational Black Americans from with roots in the West African slave trade, whose families have been here since then, are just Black applicants, as far as I'm aware. I think it's a self-reporting system, and I do think also that it's. And I commend to you reading the brief by David Bernstein and Corey Liu in this case, where they explain that most of these classifications on race are really just arbitrary as well. Right? They don't make any sort of sense. Lumping together individuals from all over Asia as just plain Asian really doesn't get at what I think the schools purport to want to get at, and that is to promote mission by underrepresented groups in the country and around the world in their classes by excluding, downgrading the personal ratings. I meant to mention this earlier. This broad group of quote-unquote Asian Americans to like 17 or 18% of their entering classes at Harvard, year after year after year, eerily, strangely, they get to that same percentage every year. They're excluding Cambodian Americans and Uyghurs or what have you who have absolutely no representation on their campuses just because they are labeled as these arbitrary, Asian Americans. My answer was I don't know, actually.
I have a question from our virtual audience. This question, I think, is a stump the panel sort of question, so I look forward to your responses. Brandon Winchell of the Beckett Fund asks, what are your thoughts on Health and Hospital Corporation of Marion County, Indiana against Talevsky, and how it will impact implied rights of action for spending clause legislation? Anyone? All right, hearing nothing. Mission accomplished. Stump the panel. Do we have other questions? Yes, I'm sorry, the lights are a little bright. It's hard to see. Please.
Isaiah McKinney with the Cato Institute. My question is for Ms. Severino, but also for the panel as a whole. One of the themes I've taken away from this panel is the question of how broad the Supreme Court is likely to go on fashioning a rule this term. And in regards to Sacket, is it likely that the court is going to fixing Rapanos, applying the significant nexus or the continuous service connection test? Or is the court more likely to get into actually defining WOTUS as a whole? And if they do that, if they go into WOTUS as a whole rather than just fixing Rapanos, do you think they're going to address the issue of tributaries as in whether or not they're navigable water?
So I think, given the fact that in this case they have an easy, clear choice between. Sometimes one of the challenges of how broad are they willing to go is if you go really broad, then you start running into other. How do I do the line drawing things, and how do I limit this, or a broad decision like a couple terms ago in Fulton, where they're like, we don't think Smith is great, but we're not really sure what else we do, so maybe we're not quite ready to go there. In this case, they have a really clear alternative. There's you go with the Scalia opinion or you go with the Kennedy opinion, and the Scalia opinion is nice and here's a two-step process, and surface contiguousness is pretty easy to, it's a much brighter line rule option that they have there. So I think in this case, you're more likely, I don't think you're going to see them go beyond that, because I feel like they're going to say, hey, we've got a nice, two-step test that several of them, I think 3 of the current members of the court have signed on to already effectively, and so it's well, let's just stick with that and maybe leave more analysis for a later day, but obviously anyone else is welcome to weigh in their guesses. None of us really will know for sure, even after we hear oral arguments in the first day of term.
Yes.
Yes, Kalen Diaz with the Washington Examiner. I wanted to say thank you again to the panelists for helping us expand both the ideas and the messaging that we use to talk about these cases, whether it's for the institutions here or the news networks. And speaking of messaging, I felt like more than anything else of all the cases this upcoming term, that for Moore versus Harper, I see the most divergent messaging depending on what outlet or what organization you're looking at or reading about. Oftentimes, especially if you're looking at, say like Democracy Docket, they will make these claims that, the independent state legislator doctrine or thing or whatever it is a right-wing theory. And it's something, it's just come to my attention that, where's the justification for, outlets that label it this? Is there anything to it there? And I mean, looking more so like what groups like the Brennan Center have said about this, they say the nightmare scenario is that a legislator displeased with how an election official on the ground has interpreted her state's election laws would invoke the theory as a pretext to refuse to certify the results of a presidential election and instead select its own slate of electors. But folks that I've talked to about this say that Moore versus Harper is distinctly a redistricting case. So I want to know where people bring this up, and is there any validity to this accusation that I've just seen around on the net?
So Derek, why don't you answer? But I think the answer might be somewhere in between, not only redistricting, but all kinds of election rules, but maybe not post-election legislative designation of new electors. Is that right?
Yeah, I mean, so there's always a nightmare scenario, so you can start there. I mean, there are always lots of things that legislatures could do, and there's no question that, if a pretty robust theory of Moore versus Harper about the legislature's power comes through, and the legislatures then start to pass new laws of things like, well, we're going to certify elections, we're going to be the board of canvassers, we're going to manually tabulate them on the floor of the Arizona Senate, like in front of everybody. I mean, there are like ways of thinking about it in sort of, spinning out from there. But setting all that aside for a moment, I mean, the question is, like, whatever the court's theory is, and again, this is the theme, right? If it says there's some constraint on other actors in the state, and the legislature has the prerogative to be able to dictate these rules, the whole game is going to be how far that goes. And so maybe in one nightmare scenario, it's whatever the legislature says goes, as opposed to whatever the state constitution says, as opposed to whatever the state court says is an independent check on them. Now, I emphasize independent check because state courts are still going to have the authority to interpret ambiguous statutes, and local election officials are still going to have to apply the rules that the legislature has given to them. And again, in most of those scenarios, no one's going to say, well, we're trying to deal with this sort of standard about how to count the ballots and what the tabulation rules are, and we've developed a rule of construction consistent with this ambiguity, and the legislature says, well, no, that's wrong. I mean, there's really no federal issue there to the extent that this is sort of ordinary statutory construction that the state courts are supposed to be doing anyway. It's really this, again, sort of as an independent check, as sort of saying, well, we are going to trump whatever you have done as the legislature. And again, to the extent that the court chooses a more modest version of the rule, and again, that it becomes much harder to draw the lines of something like, well, if we lack a clear constitutional amendment to the contrary, very few things are going to fall in that bucket. Things like interpreting an ambiguous constitutional provision like free and fair elections to mean whatever we want it to mean, are the kinds of things that might fall into that bucket. But again, the jury's out about how far the court might go and what it might lead to down the road.
And I think it's just worth noting that, I mean, even Brett Kavanaugh himself put in his concurrence that, as far as in the Dobbs opinion, that, he was not in favor of things such as like forbidding someone from going cross-state, for an abortion or something like that. So, I mean, it seems like that, they were thinking in line of the constraints of which, the Dobbs opinion could be applied to. So, I mean, is it fair to say that, there could be some sort of clarification on the matter, that just so that there's no sort of broad interpretation of it, Yeah. I mean, it is a redistricting case, right?
I mean, at its heart, this is a redistricting case, yes. But what it says here, I mean, it's picked this up for a reason. Justice Alito said, and Justice Kavanaugh wrote separately. I mean, I'm not sure Justice Kavanaugh is all on board, but on the emergency docket, when they had 3 justices who wanted to stay the decision of the North Carolina court, that was Alito, Gorsuch, and Thomas, Justice Kavanaugh did not agree. He wrote separately saying, we ought to hear this. But he didn't agree that we should freeze what happened below. And he began writing separately, thinking about the implications of this case ahead of 2024. So they solve it with a cold record rather than one coming up boiling hot in October, November, December 2024.
But it also does seem completely clear that whatever they say about the elections clause is going to extend far beyond redistricting.
Yes, yeah.
I don't think there's any way it's confined to redistricting.
But just as there is still a check. I mean, even under the strongest possible interpretation, there's clearly, Congress is right there in the Constitution. Like, if we're concerned about that states are going to be overriding things, Congress can certainly speak to that, and you're still bound by the federal Constitution. So there's no one in the case is arguing for a check-free, legislatures do your thing system. So there still will be some backstop.
I'll say, though, that I think that against our actual political moment and a lot of movements, anti-democratic movements across the country, and if you look at what's happening with a lot of election boards, et cetera, that some of the nightmare scenarios may be more plausible, right? Like, I certainly didn't think that January 6th would ever be something I would see in my lifetime. So I think that, of course, I think, Derek's totally right. The case on its own feet is not going to make the ceiling fall, but in context, it may raise really hard, scary questions before any Congress reasonably could act, namely in this election and in 24.
I have another question from the virtual audience. This one I think will be capable of addressing. If Colorado can order a website operator to say certain things about same-sex marriage, what can't it force companies to say? Amanda?
Well, I mean, the question is not whether or not it can force a website company to say a particular thing, right? I don't think that that's actually what the case is about. I think everyone would agree, including Colorado, that Colorado couldn't go around and say, all of you need to say Jesus loves gay people on your websites, okay? Everyone would agree that that violates the First Amendment. The question is if you have a equal service requirement, if you have different types of people who want types of services, right? Like writing their names on a cake, that's writing, right? And I don't want to write Pat and Pat, I want to write Pat and Jane or whatever, right? Whether or not that invokes the same type of strong compelled speech First Amendment issue and what the limits around that should be. But everyone agrees that the state of Colorado cannot go and say to any particular website, any particular artist, any particular business, you have to say X. It's only in this context of equal service where there's a closeness between identity and message where this issue is arising.
To the contrary, am I not right that the website operator could continue to say on her website that she does not approve of same-sex marriage?
100%.
But there is a challenge because, you know, I believe that this website operator said if it was the parents, say, of one of the members of the gay couple that wanted the website too, who themselves are heterosexual, it's not about like they could be heterosexual, but they want a website celebrating a same-sex marriage would be her argument there. So it's not so that it's not really about the identity. It's certainly not about the identity of the specific customer, him or herself. It's about the message being given by that website. So it does. I don't know. I just think that would be the argument for this is a message that you are sending, not an identity of the person, because she doesn't care who the person is who is buying the website or wants to.
Sure, but that would be the same thing if I went and said, I want to buy a cake for my friend's black child that celebrates their black birthday, and the person says no, right? It still is about that question, and like in Bray, for example, O'Connor says like attacks on yarmulkes is attacks on Jews, and we get to that same question of the intersection, sort of like how are we going to think about the scope of identity and its relationship with marriage? I mean, with the message.
Yes.
Hi, Jason Torchinsky. I'm in private practice. So with the court considering the Harvard and North Carolina cases at the end of October and the Merrill case at the beginning of October, do you think that since all three of those cases involve race, that the arguments in Merrill about race and the arguments about Harvard and North Carolina in race, do you think the court will sort of view those three cases in tandem, or do you think they will really divide them and so that the Harvard North Carolina decision won't have any impact on Merrill, or do you think that do you think there's an interaction between those three cases?
It's a great question. I mean, I think I read Adam's predecessor had a piece on this in The Atlantic this week, thinking about those issues, thinking about the relationship of race and more broadly on the docket this term. These are both statutory questions, strictly speaking, but involve some harder constitutional issues lurking beneath them. My sense, I could be wrong, is that the issues of sort of race and constitutionality are teed up much more squarely in the Harvard and UNC cases than in the Merrill case. Merrill, I think there's this sort of statutory stare decisis / easy evidentiary argument out to say like, well, you kind of went too far, send it back, and we'll save it for another day. But it's possible that there's some synergy between those as the court's thinking about race and the 14th Amendment more generally and brings it in. But
I don't see anyone else. One last chance, if someone has a question. Otherwise, is that a movement toward the microphone or the door? Otherwise, please join me in thanking this fantastic panel. Wait.
Adam, I wanted to give...
Save your applause. One more question.
I have a
Last
question to give you an opportunity to shine. Are we going to see people in the courtroom the same way we did pre-COVID? And are the simultaneous audio play going to continue? And then the other question I wanted to ask you was, are we going to see a report on who leaked the Dobbs draft?
So here's what little we know about those questions. Both of them come from comments at the 10th Circuit Judicial Conference. The Chief Justice said that the public will be back in the courtroom. There's not been a formal announcement yet from the court about whether that means people will be sitting knee to knee back in the courtroom as before, but the Chief knows what he's talking about. So I imagine that part of it is true. The courthouse, which has been closed to the public since the beginning of the pandemic, will open up again, and that's a terrific thing. The particular logistics about exactly how that works, we don't know. The court has said nothing about whether it will retain live audio. I think it would be a big step for them to withdraw it. I think it's been a success, but they haven't spoken on that. I would imagine in the coming days we'll have answers to those two questions. Also at the 10th Circuit Judicial Conference, Justice Gorsuch said that a report is being prepared and will be presented, presumably, to the justices. He didn't say what was in the report. He didn't say whether the leaker has been found. He didn't say whether the report will be made public. So that's what I know about these issues. Okay, now let's thank the panel.